Hello, RSA Conference 2010. My name is Matthew L. Miller, Esquire. I am a Business Development Manager at Forsyth Technology. Before I joined Forsyth, I was the Product Manager for NCASE eDiscovery at Guidance Software. Prior to that, I was an eDiscovery Solutions Specialist, also at Guidance Software, for 2 years. Before that, I practiced as a litigator at Pekar & Abramson PC. It's the #1 construction litigation firm in the country. And after that, I acted as a consultant on discovery solutions for the AmLaw 200 when I was at On-Site eDiscovery. My unique perspective will provide an unbiased, best practices approach to eDiscovery from having been a lawyer, a contract attorney, an outside vendor, and recently working directly with in-house eDiscovery software solutions. I try to enable clients to reduce their risk and implement best practices to streamline the eDiscovery process while saving valuable resources. My co-presenter is Glenn O'Brien. He is the eDiscovery Manager for Liberty Mutual, where he has worked for the last 15 years. His previous positions with Liberty include Application Development Project Manager, Business Systems Analyst, and Paralegal. Prior to working at Liberty, he was a paralegal at 2 Boston-based law firms. He has a master's in public administration degree from Suffolk University, their business school, and a BA in international relations from Clark University. So what we are going to talk to you about is the preparation for a 30B6 witness and their deposition testimony in relation to eDiscovery. And this is often the most important person to testify regarding eDiscovery for a corporation when they're involved in a litigation. They're frequently referred to as the voice of the corporation. In the context of eDiscovery, this witness is often called to testify to the steps that the corporation took to find and produce responsive documents so that they can ensure that discovery was diligently completed in good faith. Since the 30B6 witness testimony can be used for any purpose, any inadequate preparation of this witness could have heavy consequences. So it's critical that the corporation themselves have a full understanding of the role, selection, and preparation of this critical witness. The 30B6 witness's role is to testify not to the facts of the case, but rather on the company's operations, such as the IT infrastructure or accounting practices. The witness must be prepared to testify on topics such as the location of the electronically stored information. Where is our ESI? Is it on desktops, laptops, servers, file shares? Is it in semi-structured databases or structured databases? How was this data itself preserved for the subject litigation? Was it preserved in a forensically sound manner, or were alternative means used to collect? And can you discuss those topics? Who had access to the ESI? How are you able to access the ESI? So the topics can vary greatly. Some further things that might be involved. What are the qualifications that this 30B6 witness has? And what is the organizational structure of the company that you work for? Tell us about the information systems. What kind of software is used? What type of email system is being used? Are there records management policies in place? Legacy systems, backup and restoration policies. We can delve into all of this further. And I think it's key to note that Glenn O'Brien himself is the 30B6 witness at Liberty Mutual. So one of the key decisions that a company needs to make when selecting their 30B6 witness is to choose, like Liberty did with Glenn, from their internal pool of personnel who are familiar with their network, or do they hire an outside expert, a subject matter expert, to come in, do a full evaluation and analysis of the network to be able to speak to it. Also, the company should consider whether or not they're going to use one or multiple witnesses to provide this testimony. Another area that might be impacting the selection of the witness is international data protection laws, the privacy laws. Has data transferred itself over the Atlantic Ocean? Are there cross-border investigative capabilities that were necessary in this case? Are there safe harbor provisions involved? Are there binding corporate rules? All of these things need to be considered when selecting the right witness. So for the party themselves that is producing the witness, the selection of that person and their proper preparation of the witness is the linchpin that will determine the success or failure of the outcome. Failure to properly prepare the corporation's designated representative definitely could result in adverse testimony. And that adverse testimony, if they're improperly prepared, will be binding upon that corporation in the future. So it is necessary to have both an effective, repeatable, and defensible eDiscovery response plan in place that requires the organization to proactively anticipate the type of discovery that could be initiated and to help them develop the possible offensive strategy that they can employ using and leveraging both the best defensible technology they can have in place and a properly prepared person to go and give the actual testimony. Having the right witness and investing in defensible technology has always been the key to success for the overall successful implementation of any litigation readiness response plan. This witness is just as important to the organization as the technology that is used to collect and process and prepare and preserve that ESI. So to that end, eDiscovery has made the 30B6 witness an invaluable tool for both the requesting and responding party. I greatly appreciate your time. Glenn and I have worked together for about 3 years now and would really enjoy the opportunity to get on stage again together. We've worked together at other shows talking about getting the best practices for eDiscovery into an organization as early as possible so that you can respond and be prepared when the litigation strikes. Thank you so much.